Good morning, everybody, and welcome back to the Law&Crime Network. I'm your host, Jesse Weber, and thanks for joining us. We have a very, very special day for you ahead. We're going to be covering a brand new trial. We expect opening arguments perhaps later today. This is a case out of Iowa. This is a case out of Larry Whaley. He's 60 years old. He's been charged with first-degree murder in the death of a 19-year-old woman named Samantha Teeter by shooting her through the door of his apartment. Now, what makes this case super unique is that Whaley has actually been communicating with the court. Specifically, he's been writing letters to the judge in this case, Judge Christopher C. Foy, claiming a number of things. He's been claiming that he wouldn't receive a fair trial. He claimed that evidence was being withheld, that his attorneys are lying to him, that there's been witness tampering, that his cell phone and car have been stolen, that his rights have been violated. It's been such a strange case since this whole situation erupted, and at one point it became a conversation about whether Mr. Whaley was competent enough to stand trial. Well, it was deemed that he is competent to stand trial. We do expect the case to begin. We know that jury selection is underway, and we do expect opening arguments later today. Also, we have a day filled with chock full of special segments. A little bit later today, we're going to cover the top 10 craziest laws in the United States. Some of them are doozies. You're not going to want to miss any of that. We have another special segment later on regarding Matt Damon, Gene Simmons, Lorenzen Wright, Curtis Reeves. Very important subjects all throughout the day. And then finally, we're going to recap the Xavier Dobson case. We were very focused on the Todd Kenhammer case out of Wisconsin, so we really want to focus on the Xavier Dobson case. As you know, this was the case out of Knoxville, Tennessee. Xavier Dobson was 15 years old. He was a high school football player who was shot and killed when he shielded his friends from gunfire. 3 men were on trial: Christopher Jerome Bassett, Richard Gregory Williams III, and Kipling Colbert Jr. All 3 men last week were found guilty on numerous charges of first-degree, second-degree murder, or facilitation to commit first- and second-degree murder, and then several other counts of attempted murder, and well as firearm charges. Now, what we're showing you right there was that President Barack Obama spoke so highly of this young man. Xavier Dobson died saving 3 friends from getting shot. He was a hero at 15. What's our excuse for not acting? This young man was also honored in a 30 by 30 documentary, and he also won the Arthur Ashe Courage Award in 2016 for his bravery. So we're going to recap the Xavier Dobson case as well. But to help me talk a little bit about the Whaley case and the Dobson case, I'm joined by a very special guest, criminal defense attorney Yosha Gunasekera. Yosha, great to see you.
Nice to be here. Thanks for having me.
Of course. So let's talk a little bit about this new case, the Whaley case.
Yes.
Have you seen a defendant communicate with the court in this fashion? We're showing actual copies of his handwritten notes to the court. What do you make about that?
It's not good. There's a lot of information that this defendant revealed to the judge. A lot of it would just be privileged information that you would expect someone to just tell their attorney and not tell the judge that's overseeing their case. So it's going to be pretty damaging.
What kind of information has he revealed?
So one of the letters was basically a play-by-play of what happened that night.
Oof.
So for any defense attorney out there, and it's just absolutely cringing, because when someone writes out exactly what happened, they've locked themselves into a story. And one of the things is, in these type of trials, you don't know if the defendant is going to testify or not. They have an absolute right to testify, but it's a strategic decision ultimately made with both the defendant and the attorney. And really, he's locked himself into this story. And so the entire defense strategy has to be crafted around what was in those letters.
Because that could be used against him, clearly.
It could be. So it seems that he's claiming self-defense.
Right.
That's what he's saying. And so really that's what we would consider an affirmative defense. So, you know, if he's going to testify, those letters could very well come out during the defense's case.
Wasn't it at one point, really, when he got arrested or this happened, he was saying to officers, or he was whispering under his breath, they're trying to break in, they were trying to break in. He kept repeating this to himself?
Yes, he said a lot of different things. I think one of the news reports when he first got arrested was he was speaking so quietly, they couldn't hear him. He was saying some kind of erratic things.
Right.
And so I think there were some issues as to whether he was even competent to stand trial, at least initially.
What is it when you have someone to determine whether they're competent to stand trial? trial. What has the court determined about this man that, okay, they realize he can stand trial? What is the factors that they look at here?
One of the most important things is, does the person understand what is happening? Do they understand that they have been accused of a crime? Do they understand what crime they've been accused of? And can they assist in their defense? So that's a big one.
He must have been that because he knows he's writing to the judge.
Yes, well, so every defense attorney is going to be telling him, do not talk about your case to anyone. Do not reveal this information. You're only going to hurt himself. So if he keeps continuing to reach out in these essentially ex parte communications without his attorney's consent, does he really understand the serious nature? Is he really able to help himself? Because right now he's only hurting himself. So usually in these competency examinations, you go before a doctor or several doctors who asks you a series of questions to really ascertain if you are able to help yourself and understand what's going on.
I mean, he was saying that his attorneys were lying to him. I mean, that's a very strong claim to make. And how is a judge, if you're Judge Christopher C. Foy in this case, and you're hearing these allegations, how do you separate what's, all right, this guy is just talking, but maybe there's a serious claim here? What do you have to do?
Well, if the judge really had concerns about the competency of his defense attorneys, he should have assigned him new counsel. And it's really interesting because from the beginning, he started to make statements that would implicate him in the crime. I believe there was a situation where he was in front of the judge before he had been appointed attorney, and he was saying things that would, hurt his case, that indicated that he was there, that he might have shot the gun. And I think that that's why, individuals have attorneys to protect them. And so the fact that he's been saying all of these things, I think should tip the judge off that, there is some cause for concern.
So we're looking at jury selection today. We know that we're hoping for opening arguments later today. If you're the prosecution in this case, what kind of jury do you want? And if you're the defense, what kind of jury do you want?
I think if you're the defense, you definitely want a jury who has not been tainted by any of the media, by any of the letters. Especially, you do not want someone who has read the letters, and anyone who has any idea of this case, and someone who could understand that someone can do these things in self-defense. Because there's going to always be the person out there who was like, you know what? You never shoot a gun in self-defense. I don't care what you're doing. You have to make sure that someone can understand and accept your theory of defense. So you really lay a lot out there. You're putting all the bad facts out there in the voir dire, in the jury selection process, because you really want to weed out someone who's like, this is so disturbing, he must be guilty.
Right.
The prosecution then is going to want to find people who are able to understand that, you can maybe still be mentally ill and understand that something is still wrong. You want someone who just is able to accept, again, their prosecution theory. So it's going to be really interesting because there's a lot out there already on this.
Yeah, Yosha, you make really good points about this upcoming case, the Larry Whaley case, but we also do want to talk about the Xavier Dobson case, which there was a verdict last week in that case. But what we want to do right now is I want to play you some clips from last week, specifically the testimony of Dr. Eric Nielsen, who's an associate professor of liberal arts, who spoke about hip-hop culture. And we'll talk about this strategy to really focus on this rap video in this case that featured the three defendants. So I want to play his testimony because I think it's a really interesting, I haven't seen this so far in a trial, and Yosha and I are going to dissect about whether or not this was good strategy or not, because ultimately the defendants were found guilty. So right now I'd like to play you the testimony of Dr. Eric Nielsen.
A number of years, even centuries, so